okay? Oh, sorry. I'll arrange it. Yes, yes, yes. Please be seated. So, a very good evening to all of you. I am your host for today's function. I am happy and privileged to welcome our guest of honor, Ms. Renee Baptiste, Speaker, Parliament of Organization of East Caribbean States, Co-Chair ADR Committee, CLA, and our Chief Guest, Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India. I thank our Chief Guest for accepting our invitation at a short notice and for sparing his valuable time to be with us today. Thank you so much, sir. I will now request Ms. Prabha Swami to kindly present a bouquet to Ms. Rennie. I will now request Ms. Rakhi Ray to kindly present a bouquet to Honorable Chief Guest, Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India. Now I will take you briefly to the journey of Nivaaran. Nivaaran means resolution, which is a body of mediators from Supreme Court of India working towards the advancement and promotion of amicable settlement of dispute through mediation. The body today has more than 100 trained mediators. During the inevitable COVID-19 pandemic, when everything went down and got slow, Nivaaran took the initiative of converting the chaos into a learning adventure by inviting the luminaries from all across the world to join hands together in educating the world towards consensual dispute resolution through webinars, discussions, and open discussions, many lecture series, and Nivaaran hosted different dignitaries from all across the world, including honorable judges of the Supreme Court of India, honorable judges from different high courts. Till today, we have conducted more than 26 lectures and webinars. We also hosted a summer school on mediation, a 12-day event which was interactive and helped the mediators to keep themselves up to date with the development skills required for a good mediator. We would continue to make difference in the mediation diaspora. The future of dispute resolution is going to witness an absolutely new dimension with the new Mediation Act 2023. And I, on behalf of Nivaaran, would like to state in the benign presence of the Honorable Ms. Rennie and Honorable Justice K.V. Vishwanathan, Judge, Supreme Court of India, that Nivaaran will continue to make difference through its various initiatives and would play a pivotal role in the new dimensions and diaspora of dispute resolution that this Act has introduced. Ms. Rennie had a remarkable legal career and achievements, a distinguished Venetian lawyer whose dedication and expertise have left an impeccable mark on the legal landscape of St. Venice and Grenadinian. Ms. Rennie's journey in the field of law began in 1971 when she entered the Faculty of Law at UWI Barbados. After graduating in 1974, she furthered her legal education at the Hugh Wooding Law School in Trinidad. Obtaining the Certificate of Legal Education in 1976, Ms. Rennie was called to the bar at St. Venice in October 1976, making the beginning of a career filled with significant accomplishment and contribution to the legal profession. One of Ms. Rennie's notable role was to establish Offshore Services Authority, the trust authority where she served as the head for the first decade of its operations. Her expertise in offshore services led her to serve on the CARICOM Committee for the Harmonization of the Companies Law in the Caribbean, showcasing her commitment to regional legal cooperation and development. In 1986, Ms. Rennie shifted to private practice, funding her solo law practice, which later evolved into her esteemed law firm, Baptist and Company. Ma'am, please excuse me if I pronounce this wrongly because I think P is silent. Really sorry for that. Ensuring that the state's absurds of emerging trends and challenging in the legal landscape. Her role as Commonwealth election observer in Nigeria and Uganda provided her with invaluable insights into electoral management system, showcasing her commitment to upholding democratic principles and good governance. Rennie's leadership extends beyond the courtroom as she serves in various capacities such as the immediate past president of the St. Vincent and the Grenadine Bar Association, Speaker of the OECS Assembly, Chairman of the National Heroes Advisory Committee, and Director of the Institute of Political and Governance in Latin America and in Caribbean. Furthermore, Rennie's law firm collaborated with prestigious international law firms such as Anderson Global USA and Biswajit Sarkar IP Law Firm India, underscores her commitment to fostering global legal partnership and promoting legal excellence on a global scale. In conclusion, Ms. Rennie's illustrated legal career is a testament to her unwavering dedication, expertise, and commitments to advancing the legal profession at St. Vincent and the Grenadines, and beyond. Her achievements serve as an inspiration to aspiring legal professionals, and she is a shining example of the impact one individual can make through this legal journey. Ma'am, I would request you to speak on the topic Mediation, a Caribbean Experience.
Thank you very much, Madam Chair. It's a wonderful experience being in India. You could imagine a little girl from the Caribbean. We drew India, and it was always just a place out there. I'm indebted to Senior Santan for the constant invitation to come to India, and I was the most surprised person about 4 years ago when the ambassador for India to St. Vincent and the Grenadines indicated that he thinks I should come to India. And of course we had all sorts of obstacles. Honorable judges of the Supreme Court in India, distinguished senior counsel of the Supreme Court, ladies and gentlemen, I'm honored to be given this opportunity to address such an august gathering of distinguished persons in the legal profession. This is a privilege which would only happen once in a lifetime, and I would therefore cherish these moments spent here with you. There are a few faces that I know from Nivaaran just by seeing you on Zoom. Perhaps out of evil cometh good. So we might say COVID was awful, but it built a new sense of humanity depending on other humanity. When President Santan visited St. Vincent, when he was serving as president of the Commonwealth Lawyers Association, and he called like the day before to meet him at the airport. I said, is he serious? No notice? Anyhow, I will get there. And he came to my office and he saw that I had my membership certificate for CLA way back in 2013. I'm one of these individuals that when people invite me to join an organization, I want to know about it. And so I constantly would be reading about it. Then they increased the fees. And I said, well, okay, I'll wait until I can become an individual member rather than my firm being a corporate member. In the meantime, we were challenged in the region to look at alternative aspects of access to justice. This is how the whole question of mediation arose. And it was through our former Chief Justice of the Eastern Caribbean Supreme Court, Sir Dennis Byron, when they were drafting the new civil procedure rules to come into effect in 2005. Bearing in mind that the rules of the Supreme Court were last revised in 1970. We were in a new century, and therefore Sir Dennis thought that we need to use the new mechanisms for resolution of disputes. I was certainly being out of practice for 10 years and never hearing about mediation as a means of alternative dispute resolution. We only knew at the time about arbitration, and that was so far removed from the ordinary man that arbitration was only for businessmen. So I said to Senior Santan, I will have to learn something about this, because I returned to my law practice after 10 years serving as a member of parliament and as a minister. Returning to my law practice and opening the rules and seeing this procedure. It could be quite daunting, because the amount of protocols that are involved that you had to familiarize yourself with in any time that you had to face a civil court judge. You see, in the Eastern Caribbean judicial system, having introduced this in 2005 and becoming under part of the landscape of how we would resolve issues, alongside this came a project from the government of Canada called Access to Justice. And they thought they would expose some members to this mediation process as well. Well, it is new back then, because anytime you hired a lawyer, it was like hiring a hired gun. You were looking to tear off the clothes of the opponent, if possible, strip him stone naked, and get somebody to make sure the other side loses, and loses badly. Because when you hire a lawyer, you want the lawyer to tear him up. That was the whole focus and profile. Most of our matters were resolved at the magisterial level, still is today. And high court matters were resolved for persons who could afford to go to the high court. So there was this gap in the justice system. The Eastern Caribbean, you notice I keep on saying Eastern Caribbean and not specifically St. Vincent and the Grenadines, because the way the court is structured is that the Eastern Caribbean countries, independent and colonial territories, you call them territories, they are serviced under one Supreme Court. There's the Chief Justice, there's the Court of Appeal, and below that the High Court. And in most jurisdictions, there was only one judge for both civil and criminal matters. But of course, more lawyers coming out of the law schools and coming back from the United Kingdom meant that you would have more work coming to the court. And therefore, introducing the mechanism for mediation seemed like a way to lessen the number of matters that would reach or become ripe for a full-blown civil trial. It was slow in taking off because nobody wanted to hear, let's talk about it. Talk? I'm not talking about anything because I hired a lawyer to cut you up. That's the mentality. Adversarial, right down to the wire. Introducing mediation meant, and you had to sell it, it's a win-win situation for both parties. Win-win? There's only one winner. That's why I'm going to court. So I would win, you would lose. That was the mentality. Having introduced mediation under the civil procedure rules, it meant that you had to lay out in that particular protocol in the rules how would mediation work. So mediators had to be trained, individuals had to be trained. Despite the fact that the Eastern Caribbean Supreme Court had set up the Judicial Education Institute in order for authenticity to the certification to be efficacious, it had to be done through the University of the West Indies. And it was through the Faculty of Social Sciences that the certification would have its authenticity, because the Judicial Education Institute did not have a protocol for accreditation. Court-appointed, the first persons were trained in 2005-2006. There were about 15 individuals, including a few persons from the evangelical churches. These 15 individuals then sought to start to work and inform the community about mediation. Also in the protocol, for there to be some sort of interfacing with various sectors of the community, a National Mediation Committee is established to work with the trained mediators. The committee is comprised of a judge as chairman and representation from trade unions, Chamber of Commerce, the Christian Council of Churches. Yes, we have other faiths, but the Christian Council of Churches would have the most numbers. We have Baha'i, Muslims, then the evangelicals are divided into two groups, Pentecostal and evangelical. So the Christian Council of Churches is named as the body that you would select one individual from that to sit on the committee. When the committee began its work, it was very slow going. 6 years on, 7 years on, some matters were in fact dealt with. In the meantime, in Trinidad and Tobago, legislation was passed where there's a Mediation Act. Up to now, we do not have a specific Mediation Act because these rules and protocols were under our civil procedure rules. In 2018, fast forward, I got the opportunity to sit on the National Committee to learn more in relation to mediation. What persons were doing when my personal experience returning to practice after being in politics. As soon as a judge would say, I think this is a matter that can be resolved through mediation, I immediately can see the lawyer and his client on the other side, especially the client. Oh, she's government, I'm opposition. So I'm going to look for a mediator that I believe is opposition. Not realizing that as lawyers, we shed our political wings when we are in court or we are advising our clients. But they didn't see it that way, they're seeing it through the prism of political upmanship. And at the first instance when I encountered this, the judge would say, Ms. Batiste, could you name a mediator that you think would be inclined to work with you and your client? And I would deliberately choose someone that I know the other side knows they are for the political opposition. So seeing me as somebody who's aligned with government, choosing or naming before the judge someone who belongs to the opposition party, you can see the client immediately like, what? She wants the opposition to be looking at my matters? And then, when the mediation takes place, and they hear us being civil to each other, it's like their eyes tear open and say, but she's for the government. So it was a lesson to litigants that as lawyers, when we are dealing with matters relating to our clients, we are not dealing with politics. By the second session of the mediation, everybody starts to relax because we're not dealing with politics. We are looking at the issue that is before. And at the end of the session, and you do the mediation agreement and everybody has to sign off, you would hear the litigant on the other side and say, really and truly, I thought you were going to say something differently. They couldn't believe that there's this procedure. In the meantime, while we are doing this in court, the Canadian government has established through the University of the West Indies the Access to Justice Project. And in their wisdom, there was a particular segment of the mediation program that related to community mediation. Because in these small Caribbean countries, there's always a community leader where people will go to them for advice, for counsel, even to judge issues. And they felt that that would be of some assistance before the issue reaches to court. They worked as well through some community leaders, and they recruited teachers at the college level, which is post-secondary, to work with them as community mediators. However, the division is so deep, and I'm speaking about St. Vincent particularly experience, that is slow going. In some areas it works, but not in most areas. Then sitting on the committee now as a member of the National Mediation Committee, that is when I'm exposed to the reports from the other jurisdictions in the Eastern Caribbean. The jurisdictions are as follows: Grenada, St. Lucia, Dominica, Antigua and Barbuda, St. Kitts and Nevis, and the British colonies or territories of Anguilla, Montserrat, and BVI. The representatives from BVI would state that it's not half and half. 1/3 would go for mediation, but so much of the work in BVI is commercial and financial, and sometimes the clients would say, okay, the judge wants us to go to mediation, let's go, but I'm for trial. So it would drag a little bit. So that was the response through BVI. Not consistently, but it is the first thing that came to you when you were listening to the reports. Grenada has the most successful project in mediation. And when I asked a colleague, how is it that it is so successful in Grenada? Everything has history. Grenada went through a quote-unquote a revolution. They saw firsthand what we didn't see. How something can go from trying to strike a match to a full blaze in fire. And that, of course, changes the psyche of people. wanting to resolve issues rather than make them catch a fire. In the other countries, it's seasonal, like you get more matters being resolved and less matters being resolved. For us in St. Vincent, when we looked at the figures, it wasn't something that would discourage you, but it was an indicia that we need to do more work. So we determined in St. Vincent that we will go on the road and have a National Mediation Week and go in the street. So we had a pop-up clinic outside the telephone company. So we put the tent there, and we'd be sitting there with our chairs and our banner, and people stop. A gentleman who is, quote unquote, they say, oh, he's a Christian soul. And he's a Seventh-day Adventist, and he used to be a teacher, a very popular teacher in his day. So people seeing teacher standing up holding these leaflets, they say, teacher, tell me what this leaflet is about. And so he would patiently, as a teacher, go through everything, and we have to tell him, well, you know, there are other people to see. But he was so patient. Then the president of the teachers' union is sitting on the other side, and members of the public recognize him from television or in the school system, and would say, can you tell me about this, because this is the first time we are seeing this. And we did this over the last 3 years, not counting the year that Soufriere erupted, because it wasn't possible for us to do that. Then we went to the churches. And it was at one of the meetings at the churches that a lady said, would you go to mediation over a rape case? And we asked, why did you say that? She said, well, sometimes these matters are so delicate, it involves members of the family with incest, etc. And I think, she said, it is better to resolve these issues inside with the church rather than take it to court, because it exposes the victims. We listened carefully to what she indicated, but we explained to her that at this time it is confined to civil matters. So she asked, what is a civil matter? And we had to explain what is a civil matter. So sometimes we are sitting in our little ivory towers in Parliament or in court, and it's not being translated to certain sectors of the public that you would wish to latch on to these new ideas of resolution of disputes. In the meantime, the Ministry of Social Development was able to get a few of the community councillors to latch on to some learning in relation to mediation. We also took opportunity to visit the community college and to secondary schools. And there's if you know St. Vincent and the Grenadines is an archipelago of small islands. Political issues, social issues are resolved by meeting under the almond tree. So we went to meeting under the almond tree with members of the public to explain about mediation. This picture helped people to understand that it is not everything. You know, the mango tree is over the fence. You don't have to go to the lawyer to write a letter to say what is happening with the mango leaves and the mango and this falling over there. Or you have some blocks that you put on near to the neighbor's place and they want to sue you for trespass. Let's sit and let's talk. While this is going on, last year, as the Chief Justice, Dame Janice Pereira, was delivering a lecture in one of the islands, and she indicated that her administration is looking at the possibility of introducing mediation in criminal matters at a certain level. We have not yet had the privilege of seeing the document being prepared and drafted, but we are assured that such a document will be issued in due course. I want to also mention that it was sometimes disheartening sitting on the National Mediation Committee when meetings are summoned. It used to be the last Friday of each month unless the judge was not available for some other reason. It was a little disheartening that at first the trade unions were very present because they want to know more about it. And then they ceased being present at some of the meetings. But I must give plaudits to the representative from the commercial sector, who was almost always present. He had at least a 90% rate of presence on the committee. I also was privileged sitting on the committee where, because of the organization, as I explained to you how the court is organized for the Eastern Caribbean, it would mean that somebody has to work at administering all these national committees. And that individual, under the protocol, under the rules, is known as the Regional Mediation Coordinator. We held meetings to look at the fee structure. Is this affordable? Should we increase the fees? And depends on the different jurisdictions. In our case in St. Vincent, because we had COVID, followed by the volcanic eruption, so there was a slowdown in the economy. The vote was, don't increase the fees. But in some of the other jurisdictions was to increase the fees because of the, and to add new structure in the fee for persons who abandon, who cancel at the last moment, would give proper notice. So we introduced a little fee to encourage people, don't give notice the day before. So in order for you not to give a notice the day before, asking, could we adjourn? If you did it, you'll have to pay a 20 EC dollars, which is about just under 10 US dollars. So those little fees are intended to help to run the little mediation office attached to the court. It's just a room with a long table that can seat 10 and to 12 persons, a cooler, a little area to hold biscuits in case you have to leave the break into the, what we call the caucus, where the mediator may ask for a caucus with one side and then a caucus with the other side, so that the mediator can get a better grasp. Because what happens sometimes in sitting there as a mediator and you're listening to the parties, and as they get over the fluff of raising their temperature and fanning and so on, you would want to hear individually. So you get party A and you listen to them in caucus, party B you listen to in caucus, then you come back and you say, I've listened to both parties. Let's just go over this and see what is the real issue. And sometimes when you go over, you see the human psyche is the most beautiful tapestry in physics. Sometimes is some things an idiosyncrasy of someone that brings an issue to court. But when you have to sit and face each other and there's no audience to play to, then you see these issues and you realize they're not even issues that touch and concern legal matters, but they are framed as legal matters. And so the temperature goes down. Everybody sometimes end up laughing and saying, well, you know, we can shake hands on that. Zoom, of course, didn't allow shake hand, but they salute each other and say, so we done, we finish. And I'm going to sign off. God bless you. And the other one say, God bless you. It's miraculous, this thing, this human psyche. One of the strangest issues that I have encountered as working in the mediation in our context is a mediator who, because they came from a background of certain high authority, the approach was as though he is a judge. And of course, you know that in our system, after you've done a mediation session, you have to fill out an evaluation form. Did the mediator do this? What was the temperature? Were you comfortable? And you have to fill out truthfully what has taken place. So the hope is we will see what will happen with those types of mediators. I want to say as well, as I close, in the hosting of the National Mediation Week, we discovered where the gaps are and how we could fill those particular gaps. And in case I forget, I should mention, in the National Mediation Committee, the Attorney General's office is also a part of the Mediation Committee. The registrar is the secretary, and there is the mediation coordinator, whom the civil files will go to her with the court order from the judge saying this has been referred, and they will refer it. You come back in 45 days. They will give another 45 days if you're not finished, and another 45 days to bring it to a conclusion. So the little office is run at the moment. Then the mediation coordinator is also the High Court administrator. So we had to get an assistant because she has her High Court work doing alongside the mediation work. And as I close, we are facing two issues. A number of younger practitioners would not have done the course, the mediation course, with the court. So their certificates were quote unquote not recognized for court appointed mediators. For example, I am a mediator, but I do not do referrals from the court for two reasons. I'm a political figure, I'm still politically active. So to avoid anything taint, I determined for myself I would not apply to be a court appointed mediator. So there are lawyers who did the course, we have our certificates, but we didn't apply to go on the roster to work within the civil jurisdiction of the court as a mediator. But it helps us in our law practice and the other areas of work that we do publicly. The approach has been, since the increasing number of young people who have done the mediation course, to see if the court would in due course give them the accreditation. Because, for example, some would have done it in their coursework in the United Kingdom or at Windsor University in Canada, but when they apply to be court appointed, they can't be court appointed because there's not yet the mechanism to say, yes, you're certified in that particular regard. But they're reputable training institutions, and we cannot just be selfish in that particular way. Finally, one area that the court is looking at to do specific rules is in family mediation. At the moment, matters are in fact, family law matters are in fact at high court level referred to mediation, even though there's not a formal setting for doing that, as we have seen in Canada and a couple of other jurisdictions. I had the good fortune to work with mediators and counselors from the Ministry of Social Development in Trinidad. Trinidad has an act, we don't. And you listen to the issues, you listen to the strategies for determination and dispute resolution. And the training is similar, not the same, similar. We have a family court. They are persons who are counselors who are trained to assist the family court in helping the parties to come to resolution, especially dealing with matters of access in custody hearings and maintenance for children. It is hard going. It's not mediation. It is counseling of the respective parties. But it is akin to that. Legislatively, I have taken the initiative of drawing to the attention of the Ministry of Foreign Affairs, 1, the Commonwealth Mediation Manual, 2, the Trinidad and Tobago Mediation Act, and 3, the Singapore Mediation Convention. Because 2 in particular require the Ministry of Foreign Affairs to act and to bring those matters to the Cabinet. Because I sit in meetings and I listen to the experts from Singapore speak about mediation and the process and helping with business, because we have a very old arbitration act of, I think it's 1941. That is during the war. And so we have to find mechanisms that face the 21st century in the way business is done and how we could resolve those issues. We're a maritime nation as well. We have a large shipping registry. So trying to resolve issues like that with that mechanism is not the easiest procedures in the world. We are hopeful that the Minister of Foreign Affairs and Foreign Trade, who is also an attorney, would be on our side to assist us with the government. I will also, of my own volition, try to seek an audience with the Minister of Finance and the Prime Minister to draw this to his attention in a very personal capacity, to sit and speak to him, because his agenda is not an easy one at this time. I want to, at this time as well, thank Santan Sr. for those invitations sent to us about Nivaaran. I circulated to a number of lawyers who are interested, and I see an increasing number from the Caribbean region joining the summer school, and a small number from St. Vincent. I appreciate very much the opportunity for increased learning, and some of my colleagues, when we listen to speakers from New Zealand and Australia, the barefoot mediator, that there is so much we can learn because of the nature of our communities. I remain in constant touch with my dear senior to keep him apprised of the matters and progress that we have made so far. And he has encouraged me so much that I had to join the ADR committee of the Commonwealth Lawyers Association. We are examining models. We are continuously open to learning from established entities and even newer ones that are coming on the block. But however, we have to always remember we are dealing with people and to approach with caution. Thank you.
Thank you very much, ma'am, for taking us to such elaborately and showing us the perspective about mediation. And I'm so impressed about listening about the community mediation in your country. In our new act also, we have a chapter on that, community mediation. But I learned a lot from you about this. And now on common demand, we are having a small question answer session, because this is an opportunity for all of us. So we will take 2-3 questions which is of importance to all of us. Ma'am, you can just say like
yes, his accent is a little. If you can just
sir, may I request you to kindly remove your goggles? This is not a okay. You have some. All right. Okay. All right. No problem.
We have seen district mediation centers in Kozhikode. There is a common observation. And as you said, what my data is, you get me the data where you have been saying it is not failed.
You can answer. Sir, please, may respond, sir, for you.
Please, sir.
Sir, basically the question would be that we will be requesting the chief guest, with regard to their perspective of Caribbean islands. So, with regard to your queries, please be free. We are free with you, and we'll share the all thoughts. Thank you so much.
Any other question? This is with respect to Caribbean continent, right? Because in India we have so many people, we have to learn from other countries. Sakshi, you want some question?
Good evening. My name is Sakshi Ganga. I just want to know you what kind of criminal matters do you feel will eventually come into the fold of mediation, if at all? When they do, because you mentioned that it's in the pipeline. So what kind of criminal matters can be addressed through mediation, if at all?
Okay. I think the thinking was that sometimes it's a brother and a half brother and their children.
Right.
And he takes up a pebble and he fires it at their son. It wasn't, we know, there was not the intention to harm.
Right.
So instead of having that little 14-year-old having a charge for assault on his record, 4 years later he applies to go to college.
Right.
And he has a guilty charge for his police certificate for an error of taking up a pebble and hitting his uncle. If that matter can be brought where the family can sit with a person outside of the family, but respected in the community and understands the culture in particular families, to resolve that issue rather than that 18-year-old having a criminal record, it will say criminally charged for assault, and destroy his as an 18-year-old because that matter may not have even come to the attention of the school. It's just dealt with because when you're dealing with children, it's in camera. But there is a record.
Yes.
So he applies and they say you need to get a clean police record. He doesn't have one. You're going to destroy his future because as a 14-year-old, he did this. And you know, there was not that criminal intention to harm and draw blood. And you know that. It's not something that will always apply. There are 14-year-olds who are terrible. And it will be on their record. But we have now some legislation which hasn't come into effect called rehabilitation of offenders, to see how you can, what kind of personality, what was on the profile when the police did the interviews of that particular person who's charged, whether or not that person can apply to have that criminal charge expunged from the record.
Thank you so much. Any other question? Yeah, Push?
Yeah. So basically, this means that you are in line with restorative justice, because that is also victim offender mediation. Because in our country, still there are many number of criminal matters which are immune from mediation center. So it is, what suits us is more of a restorative justice. Because if we are going to take every criminal matter in mediation also, then practically law and order situation will be So I think restorative justice is better to suit with the criminal matters than in mediation, which is something different from mediation.
That is why also, as you say, restorative justice,
Yeah.
with kids do silly things when it's plum season and mango season, and they end up again running afoul of the law. What do you do with this person? Sentence them? Give them a suspended sentence? You tell them, okay, go clean those drains or carry flowers to your grandmother's grave and start to instill this discipline of doing as you're told and try to restore people, because we would have seen what harm can do being hardline. Because we have a situation in the Caribbean where some parents would leave to go to the United States on a vacation. 6 months visa. They never returned. But they didn't tell their children. So their children said, goodbye, mommy. And mommy's gone. 4 months later, she sends a barrel full of foodstuff. So they become known as barrel kids. But no mother. Nobody to nurture them. Nobody to correct them. Nobody for them to go and cry when they bruise their knees. And over time, I've spoken to a number of lawyers who work in the criminal jurisdiction of the court. And he has seen, by going into the prison, he has seen recidivists who, when you check the social background, you see these gaps in parenting, nurturing, assisting them. Because you have to teach people what's right and wrong. It is not automatic for everybody. And we don't have the same values, social values. So that value system would have been missing. And one practitioner indicated to me that he saw over time a young man become a stone killer. So what are we doing as lawyers? What are we doing as supposed to be building blocks in our own community, in our own countries? We can't just simply collect the fees and buy the biggest car. We're going to live in that community. So let us keep the balance our taste and our own ambitions for the rest of the community.
Thank you. Thank you so much, ma'am. I'll take one more question. Pooja asked one question.
No, it was just an observation that it's always a pleasure to hear, ma'am. I have had the privilege of being with you on a session also. So I would just say that Caribbean, by and large, as a country, is much smaller in size. So it's like, we cannot compare apples and oranges. India is much huge. Exactly, it's a subcontinent. But again, there is so much to take away from what you said, that it's not always retributive justice which is the need of the hour. We have to go into the depth of the situation, which eventually then we, as judges also, you need to decide whether this needs transformation or this needs imprisonment, like for the same set of, I'd say, facts, that what prompted. So that trigger point needs to be worked upon, and maybe mediation will be more successful if we were to go beyond that facilitative mode and maybe go into reformative, transformative. These technicalities should not matter in the larger context. Eventually, it's also important to see whether we are getting where we wanted to be with this need. I mean, where is the need to be so watertight and so very focused that it only has to be facilitative? What difference does it make? I keep asking myself, if I were to go into the transformative or reformative mode and tell the parties, if probably they are stuck and I know the answer what they are seeking, but still because of the facilitative I cannot tell them, which is kind of a handicap.
We as a smaller nation and younger nation, who have dynasties in
Absolutely.
thousands of years of civilization, we were transformed, transplanted from India, and we then had the indigenous people came from the Orinoco. And you had a conquering power mold a society. Now you're understanding what that meant. It made them an empire. They're not even as big as India. They're an empire that ruled the world. And these structures were meant to keep you in order. Forget it, you would have, and your ancestors come from a civilization where there were other ways of dealing with aspects. And for me, when I went to, I think it was Nigeria, as an election observer, going through a village and meeting the village elder at the polling station, We went to look at the police station, but it wasn't police there. Then we realized they were holding a hearing in the village. And it struck me. This is, something we hear about, but you didn't meet it. So now you see it. And then it takes you back to your own village, where in dramatic form, what we used to have is something called a hanging, where somebody would have done something and people would cry him, you shouldn't do that, something that is so socially unacceptable, distasteful, not criminal, but you do a mock trial and you hang an effigy of this person. And so he becomes ashamed and will go to an elder and say, I really shouldn't have done that, there was this reason, that reason. So we coming through in this century realize now, so that's where mock hanging came from. That's where tea meeting, it used to be called tea meeting, where people who can write language in a particular way want to say that some woman left her husband for her husband's brother, but you do it in poetic style of why she left the husband. He didn't buy her Christmas curtain out of her house. So there are different means of how you resolve certain things that can keep you mad. So you didn't get Christmas curtains, and you know that the brother-in-law likes you, so you sit up near to him so the husband could get jealous. And those things can have emotional effect on a family. But we didn't understand back then. It's in this century now to start to unravel because you have been educated and you got the tools of the conqueror. So you can unravel these things for yourself.
Thank you so much, ma'am. Our next guest, Justice K.V. Vishwanathan, who is a sitting judge of the Honorable Supreme Court of India, before being part of the bench, had a remarkable career as a lawyer. He was a gold medalist, college topper at Coimbatore Law College, Bhatihar University, Coimbatore. In initial days of his practice, he started working at Coimbatore with renowned criminal lawyer Mr. K.A. Ramachandran, and then joined the chambers of Mr. C.S. Vaidyanathan, senior advocate and former additional Solicitor General of India. From the year 1990 to 95, he worked as an associate to Mr. K.K. Venugopal, learned senior counsel and former Attorney General of India, and appeared with him in various cases before the Honorable Supreme Court and various high courts. He continued to practice before Honorable Supreme Court and in the year 2009 was designated as a senior advocate by full court of the Supreme Court of India. He was appointed as the Additional Solicitor General of India on 26 August 2013 and held the position till May 2014. During his career as an advocate, he appeared before the Supreme Court of India and several high courts across the country. As a senior advocate and additional solicitor general, appeared in wide range of matters on diverse subjects of law, including several appearances before the Constitution bench of the Supreme Court. I am not taking names of the matter, but I have got a gist because there was less time for me, so much of history and so much of illustrious background. As senior advocate, he argued important constitutional bench cases. He represented the petitioners in the case of right of privacy, validity of Aadhaar Act, marriage equality. He represented the interveners, Internet Freedom Foundation in the WhatsApp Facebook privacy case. He contributed to the court as amicus curiae in various cases, including the case concerning the validity of tenure extension for Central Bureau of Investigation and Enforcement Directorate, directors and judicial appointments in lower courts. In the case challenging the validity of tenure extension for ED director, he informed the court that the amendment must be scrapped in the interest of democracy. Sir is a former member of the National Legal Services Authority, NALSA. He appeared before Justice Verma Commission of Inquiry and Justice M.C. Jain Commission of Inquiry in 1991. He contributed to Justice J.S. Verma's committee report on effectuation of fundamental duties under the topic Administration of Justice. During his time as a lawyer, he made notable contribution in editorial articles in various national publications and diverse lectures in different colleges of law, and I know about it that he's wherever he is invited, he will go. And sir, thank you so much for today's sparing time for us. He was elevated as a judge of the Honorable Supreme Court of India directly from the bar on 19th May 2023. I would now request Honorable Justice K.V. Vishwanathan, Judge, Supreme Court of India, to give his presidential address on the topic mediation landscape in India. Thank you so much.
Thank you, Nandini, for that very generous introduction. Honorable Reni Baptist, Speaker, Parliament of the Organization of East Caribbean States and eminent lawyer, Shireen Kajuria, Senior Advocate, avid mediator, Nandini, Santana Krishnan, I think known as Santan to friends, and the live wire behind the Nivaaran-Mediation and the Commonwealth Lawyers Association, Mr. Jitendra Sharma, Mr. Rakesh Khanna, Mr. Ranjit Thomas, other senior lawyers, distinguished member from the Women Bar, distinguished lawyers, ladies and gentlemen, a very good evening to you. At the outset, I want to thank Mr. Santana Krishnan not so much for inviting me, but for inviting Ms. Reni to give us her perspective of the mediation scenario in the nation that she represents, part of the Caribbean islands. When we speak of Caribbean, Madam, we remember the friendly relations that India has with the Caribbean countries. And I think it's primarily driven by cricket. We have fond memories of the teams visiting us and our teams going and playing there. But never did the marshals, the holdings ever opt for mediation when it came to cricket. But the interesting aspect of your talk today, as I was keenly following you, was the broad similarities that we have in terms of the issues as well as the advantages that mediation offers, but more importantly as to how mediation, which was once in our country perhaps the most sought after and the only remedy, took a back seat with the advent of the colonial masters, and how now it is getting a revival. You mentioned about your visit to Nigeria and the community mediation which was happening there on the polling day and the mock hanging. Our history also shows, when you talk of landscape, one has to necessarily mention the history briefly, that our country was a pioneer in mediation. History reveals that Yagnavakya, one of our leading scholars, set up Kula, an organization or a body which dealt with disputes between members of the family, community and tribes. You will find reflection both in the country that you represent, Nigeria, and all parts of the our country, both the princely states and part of British India. It's interesting to read, and whenever you call me for this, you force me to read a bit. So that there's another tribunal known as Shreni, a corporation of artisans who followed the same business and dealt with their internal disputes. What we talk of Federation of Chambers of Commerce existed centuries ago. And PUGA, a similar association of traders in any branch of commerce. You mentioned about the village elders. Our panchayat is modeled on that. Our panchayats have been adopting from time immemorial conciliatory methods of redressal. As the title Nivaaran literally translated would mean redressal. You redress an issue. Just digressing a bit, one of the issues mentioned was about the lack of awareness. The normal idea is, as Honorable Speaker mentioned, that you take somebody to court, you settle your ego through the process of the court, you teach him a lesson. In the process, you have a chance of not only losing your dispute, but also losing, as they say, the relationship, which is the primordial advantage. But the lack of awareness is a serious concern, and I think that is where organizations like Nivaaran would really work on spreading the message of mediation, the advantages of mediation, the benefit in terms of cost, the confidentiality, the flexibility that it offers, the cost effectiveness, and the possibility of the relationship continuing. And I say this because in my brief experience on the bench, and that may perhaps answer the gentleman's question when he raised the question here. Whenever in matrimonial disputes I find we suggest mediation, the lawyer who has filed the case, or represents the petitioner in the court below, we get transfer petitions. So he feels that by mediation, what it means is that we are asking him to withdraw his case and deny him the relief that he wants. So times without number we tell him mediation could include resolution, amicable resolution in the sense of coming together of the couple, or an amicable parting. That message is not gone home. So the immediate reaction without even asking the party is that no, my client doesn't want. There's a lot of cruelty that has happened. So I think this awareness is perhaps where we need to work on. In India, of course, with the advent of the British, we got an established system of administration of justice, and that machinery was a more visible, was a more, the brick and mortar was available. The practicing lawyers or the pleaders or the muktars who were advising parties, their default approach was to resolve it through the court process. So that resulted in mediation taking a back seat. But mediation did surface in certain statutes. You could find a smattering of these provisions occurring in the Industrial Disputes Act, of course, the Micro Small Industries Act, the 1976 amendment to the Code of Civil Procedure and the Hindu laws brought in a conciliation procedure in Order 32A of the Code of Civil Procedure. There were provisions in the Hindu Marriage and the Special Marriage Act which introduced, not in a consolidated statute which came much later, but in these statutes. And that did help in addressing the huge backlog. I don't know how the situation in Caribbean is, but with the population that we have and the tremendous faith that the litigants repose in courts, the pendency is substantial. The statistics reveal that in the trial courts there are at least 4 to 5 crore cases that are pending. The high courts put together have about 56 to 60 lakh cases. The Supreme Court has been addressing it rapidly, and we have pendency in the range of, I think, 77 to 80,000, plus or minus 5,000. So this would be a method. At the moment, we still call it the alternative dispute method, but I am sure with the way that we have evolved, it will be first an additional method and then have its own, it carved its own niche in the arena of dispute redressal. So after these statutes, which had small provisions here and there, the Mediation and Conciliation Project Committee, constituted by the late Chief Justice of India, Honorable Justice R.C. Lahoti, in 2005, did a pilot project in the Tis Hasari trial courts in Delhi. And the success of it led to the setting up of the mediation center at the Kakarduma courts, followed by its setting up in the Rohini courts. Thereafter, conferences followed. There was no let-up even on the case law front. In the Salem Bar Association case, seeds were sown for mediation as an alternative dispute resolution. In the motor vehicles front, in the M.R. Krishnamurthy case, NALSA was directed to set up motor accident mediation cells, with slowly mediation picking up. Ultimately, in 2021, we had the mediation bill, which came on the anvil alongside the Commercial Courts Act, which had come in 2015. Some of the salient features were the implementing compulsory pre-litigation mediation in certain classes of civil and commercial disputes before parties approach a court or tribunal, facilitating online mediation, establishment of mediation councils across India to promote international and national mediation, prescribing a fixed time of 180 days for completing a mediation. It's possible, unlike in litigation, where you have the long procedure. A trained mediator can identify the least common denominator where there is acceptability and take off from that point, and as you said, have caucus meetings with one side, which is not possible in a court of law, in a secluded chamber, then have the other side. And after identifying the commonly accepted area, suggest a solution which, because of the training that the mediator has, he would be or she would be able to come out with, which even the parties would not have thought of, and which, if offered with a back of the envelope calculation, saying that this is what you have asked for, but if you fight for so many years, this is the cost that you are likely to incur, this is the time you are likely to spend. Whereas if you have a claim of 1 crore of rupees, and if you settle it for 60 lakhs, which would be 6 million rupees, in the long term analysis you would have gained. So if, with the benefit that a mediator has of an informal discussion, building a trust, that will go a long way in reducing the pendency in courts, with the result those cases which cannot be mediated. For example, criminal cases you mentioned, there are in rem proceedings which are not just between parties, and a whole host of them which has been set out in the statute which came later, could, be expeditiously disposed of. The preamble to the 2023 Act, after the bill was referred to the Standing Committee, reads as follows: an act to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body for registration of mediators, to encourage community mediation, which Nandini mentioned, which you mentioned, and to make online mediation as acceptable and cost effective process, and for matters connected therewith and incidental thereto. Most of the provisions have come into force on 9th October 2023. The Mediation Act aims to promote and facilitate mediation with a special focus on institutional mediation, online mediation, etc., which we read, seeks to extend the scope of mediation to include pre-litigation mediation. With the recent judgment of the Supreme Court in Patel Automation, was it? Patel Automation, saying that under the Commercial Courts Act, any dispute, except for some exceptional cases, has to compulsorily be mediated. So, though mediation is consensual, a condition like this, which has been held to be mandatory, would go a long way in declogging not only the courts but in giving relief in real terms to the parties concerned. Not going to bore you with the salient features which are already there for you to see, but the time limit clauses and the facility to go beyond the dispute involved when you arrive at a settlement are some of the salient features which would really go a long way in making mediation a very effective alternative dispute resolution. You did in your speech mention the emotional aspects in a dispute between parties. Today I find from the readings that integrated mediation is catching up. You associate with the mediation process a counselor, a psychiatrist, because you have the flexibility to do that, so that the emotional aspects are also taken care of, apart from the cost effectiveness, etc., that it offers. So I think from the way we have begun, of course midway there was a recession in mediation, if I may say, because of the approach that the colonial the time the nation had, but I think now it's getting an impetus, and if these are any indication, I have no doubt that mediation would in the long run be a preferred course. Parties will realize the advantages that it offers, provided the necessary awareness is created. You have eminent organizations like Nivaaran, there are other organizations. There is confidentiality, there is trust, and it is a transparent process, it is a consensual process, it is the result of it is settlement, so there will not be integrity issues, and by and large people who opt for mediation are men and women of great integrity. But what is required is a mediation culture to set in the country. Of the look of things, I am very hopeful, and I wish mediation as a process great success. I wish Nivaaran all the best, and I thank you for coming all over and sharing your views all the way from the Caribbean. So I wish you good luck. Thank you very much.
Thank you so very much for giving such a knowledgeable and valuable views on mediation. And sir, in future Nivaaran is going to look forward to take support from you on intellectual support for us. Thank you so much. Now I will request Ms. Shirin Khajuria, Senior Advocate and Mediator, Supreme Court of India, to give her closing address and vote of thanks. Come.
Thank you so much, Nandini. Thank you so much for giving me this privilege of giving the closing remarks to two wonderful speakers. In fact, it was so fascinating, the journey that you have taken us through, ma'am, of the Caribbean mediation. I don't think we really need to go to the Caribbean, to enjoy the other aspects of it. This was really fascinating for us mediators. Thank you so much. In fact, I think you've given us a very vivid view of what mediation is like, with your vast experience, including as a member of the National Commission that you have.
The kind of experience that you've shared with us, I think we've all been totally fascinated and we can really imagine it for ourselves. Thank you for that. I think one of the things which you did mention, and I think Justice Vishwanathan also said, in lawyering, what we have is we kind of tear each other apart. As far as arbitration is concerned, it is normally seen to be more for businessmen. So it is mediation which has been filling the gap in the justice system. And I think we all hope today that this is what will be noticed by the others and will take the justice system further. In fact, one of the goals that has been set by one of the SDG goals, which has been set by the United Nations, which is the Sustainability Development Goal 16, is for peace and justice and strong institutions. So I think the mediation institution across the world needs to be well established, and these are the institutions which will possibly take us to justice. So that goal, which is to be achieved by 2030, is something which I think we all as mediators need to look into. Another thing which I think you mentioned was your national committee which has been set up to work with mediators. That is a very interesting take on it, that you all have not just mediators who are involved in it, and it's not just the AG's office that is involved in it, but you also have people from different faiths, because you're a very religious, I think, nation. So I think people from different faiths are also a part of it. In India, possibly we would have community leaders. You know, we have our various strongly knit communities, especially in the villages, who would possibly be a part of it. But I think it's interesting to learn from your country as to how various members of various organizations, including, as you said, your chambers of commerce and the industry, are also members of it and can take this, the mediation process further ahead. I also found it very interesting as to how you personally had dealt with the bias against the mediator from the political parties. I thought that was very fascinating. You know, so I'm sure as mediators, we may not face it as a political party, but we could face it in different ways. And to learn to take along the other side is something which is one thing which we need to really look at. Thank you for that. Also, the National Mediation Week that you had, which includes teachers and other, you know, like you said, you would have it outside the hospitals and other organizations, and you would have, again, people who are respected in your country. That is, again, something which is interesting for us to learn from, because you're right, you know, from people like teachers is something which we all respect. And if you have them involved in the mediation process, it would definitely reach out to more people. So thank you for that. One of the things which you mentioned, which is possibly something which is also echoed by Justice Vishwanathan, is that mediation needs to be translated to the public. I like that word, translated. You know, so there is, you know, the common man doesn't really understand what the process is, doesn't really understand what the outcome is, and what the reason behind it is. So yes, that translation is something which needs to be done. And as Justice Vishwanathan said, there is a lack of awareness possibly on these aspects, and which is possibly of serious concern. And yes, Nivaaran, I'm sure, would help take this forward in the Indian context. Thank you so much for your talk. Honorable Justice K.V. Vishwanathan, thank you for taking us through the broad similarities between the two nations, as you pointed out, and the landscape of mediation in India. It was a very fascinating talk to start with the Khula system, the Panchayat system, before we had the Conciliation and Arbitration Act, which has now been replaced by the new Act of 2023. As you've also mentioned, in 2005, in fact, even the first person, I think, was Justice Lahoti, who started the Supreme Court Mediation and Conciliation Project Committee. And that has been given a real fillip by the various judgments of the Supreme Court and the High Courts. But yes, primarily the Supreme Court has been at the forefront in our country of taking this movement forward even before we've got the new law in 2023. And as you mentioned, the bill came in 2021. Some of the provisions of the Act are yet to come into force. It provides for the setting up of a mediation council. It has a time limit for completion of mediation. And it also says that we can go beyond the dispute which has been referred for mediation, which is very important. So it completely closes all disputes between two parties. I'm not sure if you have that in the Caribbean. That is something we would not. Okay, so in India they do that. And in India we also have mediation to an extent in criminal matters. Though there are some exclusions which are there in the new bill, but I think especially in matrimonial matters, the courts realize that very often it's more of a civil matter than a criminal matter, and so it can be sent to mediation. Integrated mediation is a very interesting concept, as Justice Vishwanathan has said. And yes, I guess it answers some of our questions as to whether it should be only facilitative or whether it is restorative. So yes, the integrated mediation is something maybe we all could also look at in our country. As Justice Vishwanathan said, that he has confidence that this will soon become the preferred means of dispute resolution rather than just an alternate means of dispute resolution. We need to have a culture for it, and we are all hopeful that mediation will move by leaps and bounds. Thank you so much to Nivaaran. Thank you so much to each of you for being here, and especially to our two honorable speakers. Can we please request you to join us for tea? It's just on the outside. Thank you.